my perspective on civility has evolved a bit since I've been on the bench, which has been about 9 years. And I break the issue, the problem, if you will, into two categories. In the first category, we have people who feel so strongly in their positions, so convinced that their positions are correct, that they will brook no dissent. In the courts, we see that with our pro se litigants. We sometimes see it with lawyers who feel they have a cause. And we see it in society at large, single-issue voters. There's an analogy here that, at least to me, is apt, and it similar to what went on in our free speech debates in the early part of the last century, when the government would brook no dissent. And the Supreme Court, led by Justice Oliver Wendell Holmes, began rethinking that. And the thinking was that if we are comfortable in our beliefs, then we should permit other views to be heard. This touches on matters of religion as well, but I think most deep thinkers in our major religions have recognized the potential problem when we feel so strongly about our beliefs that we won't listen or won't brook any opposition or response to our beliefs. I think that what I understand was Pope John the 23rd's motto, I think it comes from Francis, is a good way to view this issue, and that is that in things essential, unity; in non-essentials, liberty; in all else, charity. Now, I would substitute civility for charity. It's the same point, I think, that we can have strong beliefs, we can disagree, but we can be civil in how we do it. That's one category. The other category are people who, they don't know any better. They feel that being incivil gives them an advantage. And sadly, more and more, I think we see this in society, those who think that being civil is a sign of capitulation or weakness, and so they deliberately avoid being civil. Now, so that's the categories I put this in. How do I deal with it? Because let's face it, in our profession, and certainly when matters get into court, I think you have the conditions that are ripe for people acting in a less than civil manner. And I think the best way we can deal with that is to foster as much as we can, confrontation, if you will, in the sense people speaking directly about their issues. An example that I use, what I do in my court, motions to compel. No judge likes a motion to compel. Generally, they're a waste of time and money. My practice is that before a lawyer can file a motion to compel, I require the lawyer to call my chambers and schedule a telephone conference. And when that is done, we get everybody on the phone and we talk through the issue. I think I've had to do one order on a motion to compel since I've had that practice, and I've had it since I've been on the bench. And that's a small example, but I think what it illustrates is when you are in a forum where you can have that dialogue, issues get resolved. And I think that we as judges have to do what we can to promote that. And at the same time, we have to guard against the proclivity sometimes that we have of getting frustrated and perhaps being less than civil in our interactions with the lawyers and the litigants. Again, it's a friction point, and if civility is important anywhere, I think it's important in the courtroom and in what leads up to being in the courtroom.
When I first started practicing, when I first started going to law school in the mid-'70s, I was in the first wave of women lawyers, women who wanted to become lawyers. Why is that significant? Well, prior to my going to law school, there was a cadre of women attorneys who were brilliant, superstars, the best, the brightest. I am not a superstar. And that's significant in our conversation about civility, because no one was going to give me a pass because I was the smartest person in the room or the most persuasive, or certainly not the most intimidating. So when I first started practicing law, there weren't a lot of women lawyers for role models. So I thought, erroneously, that you had to be contentious and difficult and combative. And I started practicing law that way. And one day, after a very difficult deposition, excuse me, I got back to my office and I really felt sick. I thought, this isn't me. I was difficult for difficult's sake. It really wasn't necessary. Granted, the lawyer didn't know how to ask a non-leading question, but that really wasn't appropriate, my behavior. So anyway, I slept on it. Next morning, I remember very specifically getting to my office and saying, I'm not doing that anymore. I got to practice law for the rest of my career, and I can't do it. That's not who I am. I wanted to be authentically my own self, and so I changed the way I practiced. And I'm a very different lawyer now than when I first started. And like all women lawyers, I've had only about thousands of sexist comments made to me over the years. You name it, I've heard it. It didn't improve once I started actually actively practicing. I can recall one very contentious deposition where I was defending my client and I thought I was grace under pressure, and the other lawyer was clearly a bully. So after this 5 hours of deposition, the lawyer, my opponent, called me into the anteroom and he said, well, let's just say there were references to my menstrual cycle and where I was in that, and I think the B word was mentioned. And I let him go. And when he was finished, I looked at him and I said, you know, I just spent 5 hours with you taking that deposition, and I got paid well for that. That's my job. But nobody's paying me enough money to listen to your insults. Even people like me who've been subjected to this kind of, I don't want to say abuse, but certainly comments throughout my career, we think we're enlightened, we think we have all the answers, and we don't. And a recent episode really brought this home to me. I was taking a deposition in Baltimore City where I don't normally practice, and I was trailing my trial bag trailing behind me. And I walked in, and there was a woman there, and she said, oh, just go in and set up. And I must have looked totally blank. Not that I've not been called the court reporter, 1,000 times, but I don't know, it didn't compute. And she looked at me and she said, you are the court reporter. And I said, oh, no, I'm Beatrice O'Donnell. I put out my hand, introduced myself as the defense lawyer. And the poor woman just was totally mortified. She was African-American, in her 40s, and she said, after she apologized profusely, said, I know better. And in my head, I couldn't be angry, or I couldn't be upset, or I couldn't even be perturbed with her, because my first thought, I'm embarrassed to say, was she was a paralegal. So even though I know better, and she knew better, we all carry around this sort of baggage of implied bias that we have to constantly check ourselves on. So what have I learned? What I've learned is that civility is not about the other person, it's about you. It's about modeling the kind of behavior that you want to see in the world. So it puts the onus on you to try to build a relationship with your opponent. And I try to do that every single case that I have. I pick up the phone, I call them, I ask them about their practice, their likes, their dislikes, their hobbies. It's very difficult to have a contentious relationship with someone that you have a good relationship with. The other thing that I do that I think is somewhat counterintuitive is that I treat everybody the same. Now, everyone who I do business with does not have the same reputation. Some people are more difficult than others. Some people have terrible reputations. I take everybody as they are when they come to me, because I try to give everybody an opportunity to do the right thing. So your reputation really does precede you all the time. So recently I had an episode that really, I think, vindicated what I've tried to do throughout my career. We were having a mediation in our offices, and the parties were separated, and I went into the plaintiff's room to just make sure they had coffee and tea and introduce myself. And the local lawyer came up to me, who I'd only interacted with maybe twice because I was dealing with the national counsel. And he said, in typical Philly style, "I checked you out." Now, everybody checks everybody out, but they generally don't share that with you. So I said, "Oh." He said, "Yeah, it's hard to believe. I couldn't find anybody to say anything bad about you." I just kind of laughed. And he said, "No, really. They say you're the real deal." And for me, that was vindication. I tell the associates all the time, we're lawyers. We don't make anything. There's no product. We don't manufacture anything. We are the product. We're the brand. And our brand is our reputation. And I have always worked very hard to be honest, straightforward, direct, and unfailingly nice. And I think that's a successful coping strategy to have a really wonderful career.
In an ever-changing world where breaking norms seems to be a banner of honor, I think it's very important within the profession of law to maintain and, in fact, enhance civility. The public looks to the legal profession, I've seen over my 34 years of practice, to be at a greater standard, to set the stage for how society is to address their differences, how we can solve our disputes. And over the last couple of decades, I think the profession has had some tendency, certainly in the course of litigation, to fall into some of the norms of society, which may not have such a high bar. As we see the legal profession getting younger, lawyers are practicing longer. In the state of Florida, we have 107,000 lawyers. Lawyers, where 60+% of that are in small firms. Young people coming into the profession that don't have mentorship, as we did in the day. They don't know exactly, they were not taught with the behaviors, the manners that some of us who were nurtured and mentored much greater than young people have today. And they're behaving differently. I think it's very, very important that the legal profession maintains a level of civility and avoid what I've observed in many instances, incivility. I think of a particular case. Right now I happen to be the lead counsel in the Marjorie Stoneman Douglas shooting cases. That's a very intense, emotional piece of litigation where families' lives have been shattered in manners that I will never be able to appreciate from my seat. No question the vast losses that we have seen. However, it's important that we as the legal practitioners not allow ourselves to get into the emotional conflict that lay people may be experiencing, and we carry out our issues of handling the disputed issues at a level of civility. I've seen in the course of some of that litigation where it's not about bringing resolution to the legal disputes, but rather using the legal process as some form of retribution. Through that type of interpretation of the process, I've seen many examples where there is behavior that's inappropriate for the legal setting. We can always differ or disagree on our points of view, but neither should we allow our differences to lead us to behavior that would be seen on the street rather than in the court of law. In the court of law, we're supposed to carry ourselves with some dignity. Society is looking at us, and I think many times the legal profession is certainly portrayed on television as having more, scrupulous type behavior. And the only way we as lawyers can counter that is that we carry ourselves beyond reproach, that we carry ourselves with a way of creating a dialogue of differences, but not become indifferent to each other. I have seen in many instances where there's been fierce litigation, but at the end of it, the professional respect that the practitioners have, I think, is a reflection of civility. Civility that we must always adhere to. In the state of Florida, it was placed within our oath of office approximately 10 years ago. The fact that we had to put that in the oath of office is telling. My first 25 years when I took the oath of office, they didn't have to tell me to be civil. We knew as a lawyer, we knew as a professional that that was a part of what was expected. But due to the changes in society, it's now one of the commitments that lawyers coming into our practice within the state of Florida, he or she raises their hands and commit to that. We must make sure that we don't continue to slide down the slope that I believe society is facing now, where the discussions are, I'm not going to be politically correct, therefore I can behave in an abnormal, unacceptable manner, and it's seen to be okay. If ever we allow ourselves to drop down to that low bar, I believe that what is unique, what is proud about the legal profession will be lost, and we'll find ourselves just as another profession that the public does not look to us to set the standard, but rather see us as a part of just the norm, a norm that's being lowered each and every day.
I do a lot of long and difficult trials. I do trials in which the subject matter is intensely personal, in which tempers run incredibly high, and the burden that the lawyer brings to the case every day is very heavy and serious, and you have to have a proper level of detachment and civility and collegiality to survive in my practice area. One of my best civility stories is a story about when I lost my way for a moment in a courtroom in a really challenging circumstance. So I was, I would think, at least 20 years at the bar at the time, in a full-time trial advocacy practice. And I had a very difficult case that day in front of a judge that I knew well. And the facts involved my client being the only person left in the jurisdiction, his wife and children having left the jurisdiction after a court order was made that they didn't like. And so he was in a difficult position, as was I that day. And the judge, to my recollection, came out swinging. She was very agitated about the fact situation, and she was interrupting me and telling me what she thought, like right out of the gate. And about 10 minutes in to the hearing, I was on my feet making submissions. She interrupted me one more time, and I said to her, the thing that no trial lawyer should ever say to a judge, well, Your Honor, it seems to me that you've decided already what you're going to do. It seems to me you won't let me make my submissions. And so maybe I should just sit down. So I was raised by a very traditional trial lawyer, somebody who taught me that civility and collegiality are the most important virtues and one of the greatest traditions of the bar. And I knew when I was saying it, I knew I shouldn't be. And it was like I watched the words come out of my mouth like a three-dimensional object. But I said it anyways. The judge, to her great credit, and something I will always be grateful for, looked at me, took a pause, and said, "I think we need a break," stood up, and walked out of the room. So I went into the break room. I had a student with me that day, and I said to the student, "Well, that's the worst thing you could ever say to a judge, pretty much ever, and you must never say it. And I've now given you that demonstration, and now I'm going to demonstrate for you the only kind of apology you must ever make to a judge, which is entirely unconditional." So we went back in after the 10-minute break, and I said to the judge, "I apologize without condition. It was incredibly rude and inappropriate of me, and I'm sorry. And just so you know, this is my student," and I took her into the break room and told her how I was going to apologize and how wrong it was, what I did. And the judge said, "Thank you. Please proceed with your motion." And that was that. And I survived it. But there are many lessons that I learned from this incident. So I think there's two things that come from this little vignette. The first is that you can always step away. And in a lot of circumstances, the trick is recognizing the moment that you should take a break from a colleague, from an argument, from a difficult moment with a judge. There's almost no circumstance in which you can't say, "You know, I need a break. I think I'm going to step away." So lesson number one is step away. Lesson number two is you want to be the person that has the credits with the judge on the day that you're the one who screws up. And you get those credits by every day being the person standing in the courtroom with integrity, with civility, the person who points out the case that hurts them, the person who helps the judge, who helps the self-represented person. I'm always telling the self-represented person to stand up. You know, you got to help your friend on the other side or the self-represented person. And it is through those moments that you develop a bank of credits that, trust me, you need at some point in your career.
I had the good fortune of having two mentors who, from a very early stage, really demonstrated to me the importance of civility in trial practice. So I grew up in a culture where civility was recognized as an effective means of trial advocacy. I did have an experience early in my career. It was one of my first trials. There was a very senior and respected counsel on the other side, and I made a submission. It was the closing argument. I made my submissions. They were novel submissions, but I thought they hung together fairly well, and I sat down. The lawyer on the other side stood up and looked at me and said, "That's one of the stupidest submissions I've ever heard made in a courtroom." The judge, who was Justice Marvin Katzman, looked at the lawyer and he said, "There'll be no room for that sort of language in my court, and besides, sir, I thought those were excellent submissions, and if you have a response, I'd like to hear it." I must say that when he first said that, I felt quite intimidated. When the lawyer first said it, I felt quite intimidated and felt like I had probably done something that I ought not to have, but it didn't make sense to me because it was just a legal submission. And for the judge to have, in effect, called him out on his incivility made a lasting impression on me. You may be interested in the fact that this particular judge, Justice Katzman, was a very well-respected and civil judge of our trial court. He went on to be a judge of our Court of Appeal, And after his untimely passing, the Advocate Society in Ontario decided to establish an award for professionalism and civility in practice, and they named it the Marvin Katzman Award for Professionalism and Civility. What that has taught me in the context of trial and practice and advocacy is that as senior counsel, we have a responsibility. If we see incivility, then we should call it. You may not do it exactly at the time, but you should help any younger lawyer that is the subject of incivility. You should speak, if you can, to the senior lawyer if you have the opportunity. And it also says that, you know, judges have a responsibility. They should make every effort to control and ensure that the behavior of counsel in the courtroom is civil. And it doesn't take much often to simply let the lawyer know that this sort of conduct is not acceptable and will not be tolerated.